Morning, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court Law Number 2. Now, you have been asked to come to court today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies, misdemeanors. Your felony cases are normally referred to as your more serious type of criminal offenses, whereas your misdemeanor cases are normally referred as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, the first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, and the highest felony is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor criminal case. So therefore, you don't have to worry about those type punishment. But misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is fine only. You only could be given a fine, and the fine cannot exceed $500. Now, your Class C misdemeanors are cases that start in the JP court or the city court. They come to this court when the person is found guilty in the JP court or the city court, and they appeal their case, and then it comes here. The range of punishment does not change. It's still the same. Maximum you can get is a fine up, you can get a fine to $500 or below. All right. Now, the next highest misdemeanor is a Class B misdemeanor. And with the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, or a fine that does not exceed $2,000, or you could be given both confinement and fine. The highest misdemeanor is a Class A misdemeanor. And with the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 1 year, or 365 days. Or a fine that does not exceed $4,000, or you could be given both such confinement and fine. Now, you may be eligible for probation. There are 2 types of probation that a person can receive. The first type of probation that I'm going to mention to you is called adjudicated probation. Adjudicated probation. The second type of probation is called unadjudicated probation. Now, the difference between the two, with the adjudicated probation, it does result in a conviction on your record. However, there is something that is called judicial clemency, where the judge or the court has the discretion to set your conviction aside which means you would no longer have a conviction. In order to qualify, three things has to happen. Number one, you have to successfully complete the probation. Number two, there cannot be any more time left on the probation. And number three, you have to be successfully discharged or let off of probation by the probation department. If those three things happen, then the court has the discretion to set aside your conviction. Now, however, if you get a subsequent conviction or another conviction later on another case, then the case that you received judicial clemency on can be brought back up. It can be resurrected, brought back up and revived and used against you. Now, if you try to get a license with Child Protective Services, which is CPS, they can deny giving you a license, or if you have a license, they can suspend or revoke that license. Now, the next type of probation, as I mentioned to you earlier, is called unadjudicated probation. With the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete it, you may qualify for what is called a non-disclosure. And what a non-disclosure is, your record is sealed to the general public. So which means the general public cannot have access to that criminal offense. And so therefore your record is sealed to the general public. Now, the operative word that I've used is general public. And what that simply means is the general public cannot have access, but the government, there are lists of governmental agencies in the Code of Criminal Procedure that can have access to it. But most of the public is the general public, so they cannot have access to it. Okay. Now, as a defendant in a criminal case, you have rights. Now, the first right that I'm going to talk about is your right to have an attorney. Now, everyone should have a clipboard. You should have that first document should be titled Judge's Explanation of Rights to Defendants by Attorney. I'm going to go over that document with you. Now, that document states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you want an attorney to represent you, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. You can represent yourself if you waive your right to have an attorney or give up your right to have an attorney. Now, the first paragraph below number one states that if you would like to have an attorney, you have enough money to hire an attorney, your case will be reset. Reset means we'll give you another court date from today to give you time to hire your attorney. The second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first sign a financial questionnaire. Now, the financial questionnaire is a document, a 3-page document that is on the clipboard. It is titled Jefferson County Affidavit of Indigence. Now, that document, if you turn to that document, you will have to, for those individuals who will be requesting a court-appointed attorney, you would have to fill out the first page of the document. And if you turn to the second page, you'll fill out the top portion that is titled Defendant's Oath, and the middle portion that is titled Unsworn Declaration by Defendant, and then you'll stop. All right. Now, if we go back to the first document, Judge's Explanation of Rights to Defendants Without Attorney, the third paragraph states, and this paragraph is for individuals who will be waiving or giving up their right to have an attorney. They'll be representing themselves. They'll be acting as their own attorney. That third paragraph states that you may not speak to the prosecutor unless you first sign a written waiver of your right to an attorney. Now, the prosecutor is one of the assistant criminal district attorneys. We have 3 of them here today. We have 1 in here right now. If you are representing yourself, you will have a right to talk to one of the prosecutors to see if you can work out a settlement on your case. the settlement, normally what we call it a plea bargain. You wanna work out a plea bargain, you wanna work out a settlement on your case, and if you're representing yourself, you would have an opportunity to talk to one of the three prosecutors about working out a settlement. Now, you cannot speak to the prosecutor about your case unless you first sign a waiver of your right to have an attorney. Now, the waiver of your right to have an attorney is another document that is on the clipboard. And this is only for individuals who will be representing themselves. The document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. So if you are wanting to represent yourself, you have to sign that document, and then you'll have an opportunity to talk to one of the prosecutors, see if you can work out a settlement case, or if you just want to represent yourself in the trial, you still have to sign that document. Now, the next paragraph, which is in block form, states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, the last paragraph, it's a one-sentence paragraph, it states, if you decide to waive your right to an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you waive your right to have an attorney, and you decided to talk to the prosecutor to see if you can settle your case. You didn't like what they were saying. You just said, hey, well, I think I'm gonna get a lawyer. I want a lawyer. You can do that. Okay. Now, in bold letters at the bottom of that document, it states defendant's choice. Mark initials next to only one choice. Now, everyone is going to make one choice. If you want to hire your own attorney, then you'll place your initials on the first line to the left, and then you'll stop. Now, if you already have an attorney representing you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you would like to waive your right to an attorney, that is, give up your right to have an attorney, you would like to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines that I've just mentioned, then you will sign your name on the line that is titled defendant, and you will date it today's date. Okay? Now, just a brief recap, everyone is going to sign that first document. Judgment explanation of rights of defendants without attorney. You're going to make a choice. Your choice is to hire your attorney. You put your initials on the first line, sign it at the bottom. Stop. And that's the only document you have to sign if you are hiring an attorney. That's it. For individuals who will be asking for or requesting a court-appointed attorney, then they will have to put their initials on the third line, sign and date it, and then they'll go to the Jefferson County Affidavit of Indians, which is a 3-page document. They'll fill out the first page, the top portion of the second page that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then they'll stop. Now, for individuals who will be waiving their right to an attorney, will be wanting to represent themselves, you'll place your initials on that first document, judgment explanation of rights of defendants without attorney. You'll place your initials on the fifth line, sign it and date it, and then you will sign the document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Once you read and sign that, then you stop. Anybody have any questions? Okay, no questions. All right. Now, before we go through all of those documents, give you an opportunity to read it and sign over those documents, I need to inform you that you also have a right to have a trial by jury. That's for individuals who will be entering a plea of not guilty. So you can enter, I'll just explain this to you. You can enter one of three types of pleas. One type of plea is when you enter a plea, you say, I'm not guilty. Not guilty basically means that you're telling the court that you did not commit the offense that you have been charged with. Another type of plea is you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges. All right. Now, if you enter a plea of not guilty, you have a right to have a trial. One type of trial that you can have is called a jury trial. And that area over there where you see those 12 chairs, 6 citizens from Jefferson County will be selected to serve as jurors in your case. And the reason why I say 6 because in county court at law, only in a misdemeanor case, you only have 6 jurors. District court, felony court, you have 12, but we have 12 chairs, but you have 6 citizens selected as jurors. They will listen to all of the evidence, listen to the arguments of the lawyers. They will go into the jury room and deliberate, and then they will decide to either find you not guilty or guilty. You also have a right to waive or give up your right. That's what waive means. You have a right to waive your right to a jury trial or give up your right to a jury trial. And if you do so, your case will come before the judge in one of 3 ways. One way it can come before the judge is by way of a bench trial. That is, you enter the plea of guilty. You don't want to have a jury trial. You want to have a bench trial. What a bench trial is, it's a trial by judge. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence, listen to the arguments of the attorneys. The judge will apply the facts to the law, and then the judge will decide to find you either not guilty or guilty. The other way that your case can come before the court is if you enter a plea of guilty or no contest. If you enter a plea of guilty or no contest, then your case will come before the judge by way of a plea bargain. It will come before the judge by way of an agreed plea bargain. What an agreed plea bargain is, it means that you and the state have reached an agreement to settle your case. So let's say you're in the state of talk, or you and your attorney in the state of talk, and they agreed for deferred probation. Then, if that's an agreement, it will come before the judge. The judge can do one of 2 things. The judge can accept or reject the agreement that you have made with the state. Now, if the judge rejects your agreement that you worked out with the state, you can take your plea back. You can take your plea of guilty or your plea of no contest back. In essence, you're just telling the court, well, judge, since you're not going along with the plea bargain agreement that we made with the state, I'm not going to enter a plea of guilty and I'm not going to enter a plea of no contest. I take it back. You have a right to do that. Now, if the judge does follow the plea bargain agreement and say within 30 days, you would like to appeal your case because you'll have 30 days to file a motion for new trial and appeal. If you would like to appeal your case, then you would have to get permission from the judge that went along with the plea bargain agreement. If the judge gives you permission to appeal your case, then your case will leave this court and go to the 9th Court of Appeals, which is located right above us on the 3rd floor. There are 4 justices up there. They will review your case to see if this court committed an error by convicting you or whether or not you were wrongfully convicted. They can do one of 2 things. They can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Case over. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to another court, a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is the highest court in the state of Texas, the highest criminal court in the state of Texas, and they are located in Austin, Texas. Now, you have to file what we call a pro se petition for this discretionary review. I will explain it to you. Pro se means that you are representing yourself. Pro se. You're by yourself. You don't have an attorney. You represent yourself. And petition for discretionary review means that you are petitioning the Texas Court of Criminal Appeals to review your case, to see whether or not your appeal should have been granted by the Ninth Court of Appeals, or whether or not this court committed an error or this court wrongly convicted you. They can do one of two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty. Case over. Or they can send a case back to the Ninth Court of Appeals with an order, or they can send it back to this court with an order. Now, if they deny your petition, then at that point, your conviction will stand. All right. Now, as a defendant in a criminal case, you also have a right to have what is called an unagreed plea bargaining agreement. In essence, you want to plead guilty in no contest. You and the state have not been able to reach an agreement. You don't like what they're saying. You don't like what they offer. And so you want the judge to decide. For the judge to set the punishment. Okay? And the judge will set the punishment anywhere within the punishment range. That is, he can give you jail time and fine, or probation, deferred probation, or what we call unadjudicated probation or adjudicated probation. So anywhere within the punishment range. All right. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. The case going to trial, you have a right to call witnesses. And witnesses sit in that chair back there with the microphone. We call that the witness stand. And what witnesses will do, they can testify for you or against you. If you have an attorney, or if you represent yourself, you can ask a question. You represent yourself. If you have an attorney, your attorney can ask a question. We call that either direct examination or cross-examination. You also have a right to call witnesses, or you can waive your right to call witnesses. Now, if you waive your right to call witness, that means that you're giving up your right to call witness. It means that you will not be calling witnesses in the case. It does not mean that the state will not be calling witnesses. Now, they will be calling witnesses. Now, if you don't call witness, that's the choice that you make. Now, you also have what we call a Fifth Amendment right against self-incrimination. And what I mean by that is this. The Fifth Amendment of the United States Constitution gives you the right to remain silent. That simply means that the state, the prosecution, the government cannot force you to take the witness stand. They can't call, if your name is John Doe, the state can't say, well, judge, at this time we call defendant John Doe to testify. You can't do that. Because if you invoke your Fifth Amendment right against self-incrimination, you have a right to remain silent, because guess what? It is not your burden to prove that you committed a crime. It's their burden. They have to prove it beyond a reasonable doubt. You don't have to prove nothing. You can sit there and don't say a word if you invoke or exercise your Fifth Amendment right against self-incrimination. Now, you can waive your Fifth Amendment right against self-incrimination, and that simply means that if you waive or give up the right to testify, that means you will be testifying in your case. Okay, and then the state can ask you questions. They can cross-examine you. All right. Now, also, you have a right to have what we call discovery. Discovery simply means that you have a right to see the evidence or discover the evidence that the state has in its file. So any witness statements, your statements, police reports, lab reports, photos, video recordings, audio recordings, documents, instruments, whatever they have that they'll be using against you in your case, you have a right to see it. You have a right to have access to it. Okay, now you can waive or give up your right to have discovery, but that's your right, your choice. All right, now, everyone that's here today, when you're here for your case, and one, you've been charged with an offense, you been arrested, placed in jail, you bonded out of jail, you either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on what we call a PR bond or a personal recognizance bond, which means you didn't have to pay any money to get out of jail. You were just released under your own personal recognizance. I say that to say this. Every day that you spent in jail can be used as credit towards your punishment. For example, let's say you spent 5 days in jail. Let's say you talked to the prosecutors, the attorney talked to the prosecutors, and they offered to settle a case for you to serve 5 days in jail. That simply means you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you will be given credit for the time that you've already served. Now, if they offer 7 days, you spent 5 days in jail, that means you will have to spend 2 days. Why? We will subtract 5 from 7, and that leaves 2. Now, every day that you spent in jail can also be used as credit toward your fine and court costs. But every day that you spend in jail, you are credited $100 per day that can go toward your fine and court costs. So for example, in our scenario, you spent 5 days in jail, that's $500 that can be used toward your fine and court costs. So if the state is offering fine and court costs of $500, that means you don't have to pay because we were tax and retired because the 5 days you spent in jail has already paid it off. Now, if they offer fine and court costs of $700, that simply means that you have to pay $200 because we subtract the 500 from 700. All right. Now, if you cannot pay the $200 balance, then we can put you on a payment plan where you can pay in small monthly installments until it's paid off. Now, perhaps you may not have the income to even pay off a payment plan. No problem. Because we can convert your fine and court costs to community service. And for every 1 hour of community service that you perform in a nonprofit organization in our community, you will have $12.50 that will be credited toward your fine and court costs. So for example, in our scenario, you owe $200. If you work 8 hours, community service 1 day, that's $100. So if you work 2 8-hour days, that's $200 in the fine and court cost, the balance is paid off. All right. Jefferson County, the district attorney's office, that is, has a program for individuals who haven't been in trouble before. The program is called pretrial diversion. With the pretrial diversion program, they will dismiss your case. And once you complete the program, you can get it expunged, which means erased, deleted, or wiped off from your criminal record. Okay? In order to qualify, 3 things has to happen. It has to be your first time, getting into trouble. Second thing, you have to have an attorney to assist you with the application process. And the third thing, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. So if you qualify, get into the program, they dismiss the case, you complete the program, you can get it erased, you can get the offense erased, deleted, and wiped off from your record. We call it expungement. And the next thing is, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans First, which is Veterans Only. Only thing you have to do to get into the program is to be a veteran of any one of the branches of the United States military. And what they will do is, once you get into the program and complete the program, then they will dismiss the case, and you may qualify for a non-disclosure. You can get a non-disclosure rate when your record is sealed to the general public. Now, this court County Court at Law No. 2 of Jefferson County, Texas, has a program that go out and they need to start within the first 100 days of taking office. The program is called the Community Safety Initiative, or short CSI, the CSI program. And with that program, we have partnerships with various agencies, and the program is designed to address the issue of what we call recidivism. Recidivism just simply means where people commit crimes over and over. And so with the partnerships that we have in our community, we are able to address certain areas. So for example, we have a partnership with Spindletop, which Spindletop is our local mental health center. And with the Spindletop Center, what they will do is they will conduct a private interview in the jury room at their facility or by telephone, whichever is convenient for the individual. They will also do an assessment to determine what the mental health issue may be, and then they can develop a treatment plan for either outpatient or inpatient treatment. Now, in order to participate in the program, you do not have to be incompetent or insane. You can just merely suffer from anxiety, depression, or any other host of mental illnesses. And Spindletop has the expertise to address your mental health needs. Now, if you have issues with drugs and alcohol, it's not uncommon for individuals who have mental health issues to also have issues with drugs and alcohol. Well, Spindletop has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OZAR. OZAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do is they can conduct the screening, do an assessment, and then develop a treatment plan for either outpatient or inpatient treatment. If you're unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, then it will assist you at getting a job in the area that you're trained in. If you have not graduated from high school, if you do not have a GED, well, they also have a GED program where you can receive your graduate equivalency diploma. Now, all of those programs that I just mentioned are free. Does not cost you anything but time. And I like to say in this court, County Court Order No. 2, we do not just give time. We take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law No. 2 of Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes in the community. So if you're interested in any one of these programs, just let us know. And we'll be happy to direct you to the people that you need to talk to get into programs. And we also have brochures as well. Now, we're getting ready to go into recess to give you time to finish filling out the paperwork. Once you finish filling out the paperwork, we're gonna call you up before the bench one at a time to go over the paperwork. And we're gonna put you in one of three categories. You're either gonna be in the category of wanting to hire an attorney, or to apply for a court-appointed attorney. And if you apply for a court-appointed attorney, your court-appointed attorney will be appointed today. Or if you want to represent yourself and waive your right to an attorney, then at that point, you'll talk to the prosecutor today to see if you can work out something in the case. Okay, now it's going to take us a little time to pick up the paperwork. If you need to use the restroom, there are two restrooms right outside in the hallway. We have the men's restroom in front of county court number 3, which is right next door. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. Now, you'll be allowed to go out into the hallways, use the restroom. And when you finish using, please come back in the courtroom. Do not leave the courthouse. If you leave the courthouse and we call your name, you do not answer, a warrant can be issued for your arrest because your bond will be forfeited. And your bond is forfeited, you'll be arrested, placed in jail, and we have to go through this thing all over again. Okay. And so we're gonna try to do this as quickly as we can. If you need any assistance with the paperwork, we have our court personnel, including myself, who will be happy to assist you with finish filling out the paperwork. Now, before we go into break, be mindful that we're in court, so continue to conduct yourself accordingly. Okay? At this time, we're going into break. And then if you need assistance with filling out the paperwork, just raise your hand. Or if you're finished with filling out the paperwork, you can raise your hand, we can come and pick it up, and so we can go ahead and finish the process. Jefferson County Court, Law number 2 is back in session. The court is in session with the jury trial docket. When I call your name, please come forward with your attorney. First case is cause number M328100. Case is styled State of Texas versus Michael Hall. Mr. Hall, would you please come forward?
He was just here 2 seconds. He's in the restroom, but we're ready on that.
Okay.
State's also ready.
State's ready? Okay. Next case is Sagar Patel. Oh, good morning. How you doing? This is cause number M328052, excuse me, 050. Case is filed in the state of Texas versus Sagar Ajes Kumar Patel. Mr. Patel, is that your full name? How you doing, Mr. Patel?
Surgery.
Okay. Okay, we hope that you have a speedy recovery. Now, Mr. Patel, you're represented in your case by your attorney, Gertz. Attorney Gertz, what's your announcement in Mr. Patel's case?
Judge, we would otherwise be ready. Mr. Patel is recovering, as you can see, from gallbladder surgery and has had some complications with that. And so I'm afraid we probably need at least 6 to 8 weeks resetting. And like I said, we're ready on Mr. Hall. So
State,
Yeah, state's only concern is that it's a case from 2020, Your Honor.
it's the oldest one on the, actually, it's the oldest on the docket by 7 days,
And
Mr. Hall.
the state will defer to the court on decision making.
Oh, I mean, if you wanna, I mean, he doesn't have a written motion. I mean, that's not a motion. He's asking, I guess he's applying, it's an oral motion for continuous. There's no written motion.
Judge, my concern is that I don't know.
Hmm?
You know, we were aware of Mr. Patel's surgery. We weren't aware of the complications that were going on. My concern is that it would be adverse to my client's interests and for him to be wincing over in pain during
I
the
understand.
middle of a jury trial. So if the court would like me to get written sworn motion, I'm happy to do that.
Well, I was just making a statement to the state to see what their position was.
State's not going to object, Your Honor.
Okay.
But
So,
would also ask that this case be given priority.
preferential setting?
It's
Okay.
fine.
Let me see, defense or motion. State no objections, Okay. Give us a date. July 21st? Is that enough time?
It's enough time, Judge. My concern is I've got a vacation letter that week. I'm
Okay.
out of the country
Okay.
at the
What's the next?
go one more week. Fourth.
August 4th? So this case will be reset to August 4th, 2025. Mr. Patel, you're gonna get your reset from our coordinator. Once you get your reset from our coordinator, you'll be free to go. And again, pray that you have a full and complete recovery. Is that Charles Ritchie? That door is locked, sir. Okay. Mr. Ritchie, your full name is Charles William Ritchie Jr.?
Yes, sir.
How you doing, Mr. Ritchie?
Doing well. How are you?
Oh, I'm doing fine, thanks for asking. Mr. Ritchie, you're representing your case by your attorney, Ryan Gerst. Attorney Gerst, what's your announcement, Mr. Ritchie?
Judge, we can be ready on Mr. Ritchie, but if we proceed on Mr. Hall, obviously we can't get reached on Mr. Ritchie, so.
I understand. Well, right now, we'll have Mr. Ritchie to come back
And
Ready unless called, that's the.
at 1:30.
Yeah,
like-
that's fine.
states ready with the caveat that the blood expert would only be available Thursday afternoon, Your Honor.
Okay, we got a unlawful carrying a weapon case too. so- All right,
And I've stayed with you putting on witnesses on Wednesday as well, Your Honor, but
Okay.
just the blood expert is only available.
okay. So Mr. Ritchie, we'll see you this afternoon at 1:30.
Thank you, sir.
All right. Did Mr. Hall ever come in?
He's here now.
Oh, Mr. Hall, okay. Okay, Mr. Hall, your case, your attorney announced ready, you need to be back here at 1:30. This afternoon. Yes. Hey, okay. Let's see, was that,
What happened?
oh, Richie,
Did
okay.
you say?
Daniel Wallace?
Yeah.
Is there a Daniel Wallace? That's yours, Mr.
It
Kurtz?
is mine, but he was here earlier, I'm not sure why.
That's I got. Hold on a minute. I can't tell this.
Good job.
You can have H.
I don't see him, maybe hold our announcement on him.
Okay,
I can be ready if we got reached on that too, though.
okay. What about the state?
On that case, Your Honor, state's going to be making, well, an oral motion for continuance, be due to a key witness having a family emergency.
I'm not opposed, obviously, Judge.
Okay. That'd be granted. Basically continued. What's the court date? July 7th. He's the same, he won't be available.
I'll be here July 7th.
I didn't give.
You gave, okay, I thought it was, okay, so July 7th. 25, okay. And Mr. Gerst,
Yes, Judge.
we'll see you this afternoon at 1:30.
You shall. Try to keep it entertaining. Judge.
Okay, have Mr. Wallace to come in to get his reset.
I'll have him come check back in.
Okay. Okay, Mr. Joshua Cormier. Calls number 24 CCCR 0912, Attorney Kimler.
The state does have a file motion for continuance.
Yes. I have it. Mr. Cormier. Full name is Joshua DeAndre Cormier.
Yes, sir.
How are you doing, Mr. Cormier? That's good, Mr. Cormier. You're representing the case by your attorney, Attorney Wright Kimler. Attorney Kimler, how are you doing?
Well, Your Honor,
That's good. And Mr. Kimler and Ms. Simmons, I have before me a motion, a state's motion for continuance. Mr. Kimler, have you had an opportunity to review state's motion?
I have reviewed it, Your Honor, I understand the circumstances, and I'll be doing a better job.
No objections? Okay, so the court is going to grant the state's motion. Is Cormier? It's gonna be granted. And Mr. Cormier, you're gonna get your reset. Your case is gonna be reset for trial. Or continue for trial. You're gonna get your reset from our court, and once you get your reset, you're free to go. You have a blessed day. Jeremy Lee Ford. Mr. Ford,
Sir.
your full name is Jeremy Lee Ford. How are you doing, Mr. Ford?
Good, how are you?
I'm doing fine, thanks for asking. Now, Mr. Ford, I have before me a motion for continuance in this case, and Mr. Kimler, have you had an opportunity?
Same announcement, that's the same.
No objections? Okay, okay, Mr. Ford, your case is gonna be reset. Give you another court date. You're gonna get your reset. Once you get your reset, you're free to go. You have a blessed day. As both of his cases.
This would be what's a good time? Six. It's not frozen. It says AC. It's pretty good. What priced your exterior units?
Destiny Connect,
Good, good.
full name is Destiny Connect.
Yes, sir.
How are you doing?
Good, how are you?
I'm doing fine, thanks for asking. You're represented in your case by your attorney, Ryan Kimler. And Mr. Kimler, I have before me I have a motion to continue in this case filed by the state. You have any objections?
No, good.
Or objections? This motion will be granted. And you can get your reset from our coordinator. Once you get your reset, you're free to go. You have a blessed day. Craig Simmons,
This was kind of old, but we're not gonna object to the motion.
okay, so, Mr. Simmons, your full name is Craig Stephen Simmons?
Yes, sir.
How are you doing, Mr. Simmons?
I'm doing good. How about you?
I'm doing fine, thanks for asking, Mr. Simmons. State filed a motion for continuous. Your attorney is not objecting. This motion will be granted. You'll be able to get a copy of your reset from our coordinator. Once you get a copy, you're free to go. If let's stay in contact with your attorney, your bonds will be here. Okay, Mr. Skimler, I think that's your last one. You're free to
I
go. You
think
have
I
a
don't
blessed
need
day.
to be back at 1:30.
No, I mean, I don't see you on here like she had all of your cases.
Good luck.
Okay, Rachel Woodson. Okay, code is in session of three cases, cause number 333-802, cause number M333-806, and cause number M333-804. All three cases are styled in the state of Texas versus Rachel G. Woodson. Ms. Woodson, is that your full name?
Yes, it is.
How are you doing, Ms. Woodson?
All right, how are you?
I'm doing fine, thanks for asking. Ms. Woodson, you're represented in your cases by your attorney, Attorney Marvel Provo. Attorney Provo, how are you doing?
I'm doing fine, y'all.
That's good. Now, Ms. Provo, what is your announcement in Ms. Woodson's cases?
We're ready.
Okay, state.
Okay, Your Honor, the state and defense have reached an agreement on one of the three cases. As for the two other cases, one of the cases will be dismissed, but the other one state's announcing ready on. I will have the exact cause number for you in just a moment.
Oh, okay. Just, are we gonna hold on it? Have a seat and we'll call you back up.
Oh.
All right. Okay, let's see. All right.
I think that's the whole 6 thing.
Do we have a paperwork for the folks on the rainbow?
I just want to be sure.
Okay.
Okay. Arthur Bushnell.
Okay.
Mr. Hugh. Rachel Woodson. Please come forward. Okay, so court is back in session. And Rachel G. Woodson's case is Mr. Hubel. What's your announcement?
On M 33802, the same defense have reached an agreement for restitution in that case.
Okay, restitution.
On M 33804, state is ready, and on M 33806, state will be submitting a dismissal.
Dismissal. Okay. So ready on 804, that's right,
That's correct, Your Honor.
and defense.
I guess you're right.
Okay, so we'll see y'all at, let's see, now okay, so you're gonna be submitting the dismissal?
That's correct.
Okay, and the restitution, what's the agreement on that? Is that restitution for dismissal?
That's correct, Your Honor.
Okay. Okay, now, the restitution, when is that to be paid?
It's, restitution's in the amount of $200, and state will submit the dismissal once it's paid. I'm not sure
We
when.
can start November. Not today.
Okay.
What do you-
How much time do you need?
Yeah. Oh, yeah, just let me.
Okay.
Do I have to come back to Texas again? Okay.
Well, I guess you're going to, okay, let me do this here. Put this on mute. First case is cause number 25 CCCR 0882, case is style of state of Texas versus Trenton Wayne Parker. Mr. Parker, your full name is Trenton Wayne Parker.
Yes, sir.
Mr. Parker, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God? You may put your hand down. How are you doing, Mr. Parker?
Good, how about you?
I'm doing fine, thanks for asking. Mr. Parker, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Sir.
Is this your signature on the line that's titled Defendant?
Sir.
Or are these your initials on the line that's titled, that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Parker, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Parker, read your answers. Your case is going to be reset. You're going to be given a reset date to give you an opportunity to hire your own attorney.
Sir.
Now, Mr. Parker, how old are you? 21? Okay. Now, are you here by yourself?
Dad.
Your dad? Okay. Now, I always, tell young people this. I know I used to be young at one time. I was your age for 365 days. Okay. And, a lot of times young people put stock in their friends. I know that today y'all call them your BFFs, best friends for life. They're your ride and die. In my day, we used to call them my ace boom coon. Okay. We used to put a lot of stock, but I'm gonna tell you something. Everybody's not your partner. Well, everybody's not your friend. Everybody's not your partner. But when that man said he got you, he got you. Your friends that ride or die that you call your ride or die, your best friends for life, they not here today. They had something else to do. But that man took time out from his schedule to be down here for you. And the reason why he's down here, because he loves you. Okay. So you need to be thankful to God that you have somebody that supports you. I know that's the man that put a roof over your head, clothes on your back, food on the table, and sometimes a little spanking on your butt. And he did all of those things because he loved you. So you're blessed to have somebody like that. I know that this is not the proudest day of his life. Okay. You might think that you're going through a storm in your life. But let me tell you this here. When you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet song of the Lord. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart and you never walk alone. Okay? So somebody might look at this as a stumbling block, but you could view it as a stepping stone. And people use stepping stones to reach higher heights. So whatever dreams that you have, you still can reach it. This will not stop you from being the person, the man that man made you to be, and to be the person that you know you can be. Okay. So at this time, you probably need to get that young man a big hug sometime today. Okay. But your case is going to be reset. Once your case is reset, you're free to go, and you have a blessed day. And tell your dad, hang in there with him. Hang on, don't hang up. All right. We've all fallen, we all made mistakes. We've all sinned, fallen out of the glory of God. But we have a God of another chance. Okay. This is not the end all for it. All right. You just got to keep on moving. Okay. All right. Once you get your reset, you're free to go and you have a blessed day. You're welcome. That was Parker. Okay, here you go. Michael Bushnell. Okay. Good morning. How you doing, Mr. Bushnell?
Well.
Oh, that's good. Yes. I'm looking for it. Oh, you know what? I'm gonna need some documents. Mr. Bushnell, I have before me a document that is titled Information. Actually, this document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Bushnell, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Bushnell, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Bushnell, your case is going to be reset to give you an opportunity to hire your attorney. But before it gets reset, we're going to give you have to give you some bond conditions. Can you make a copy right there?
Yes, sir.
Mhm. Okay, Mr. Bushnell, the bailiff is going to. Okay, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court Law Number 2. I'm going to go over these bond conditions with you. And it states Standard Bond Conditions in County Court Law Number 2, following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol and test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location triggered by the alleged victim. You understand that condition?
Yes, sir.
Condition number 4 does not apply. That only applies in a DWI case. Your case is not a DWI case, however. Condition number 5 does apply, and it states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, the warrant issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Mr. Bushnell, please stand in front of the court coordinator to get your reset. Once you get your reset, you're free to go, and you have a blessed day.
Thank you.
Denisha Wiley. Your full name is Denisha Wiley, is that correct? Ms. Wiley, would you please raise your right hand? Ms. Wiley, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Wiley, you may put your hand down. How are you doing, Ms. Wiley?
Congratulations.
Oh, I'm sorry to hear that. Now, Ms. Wiley, I have before me a document that is titled Judge's explanation of rights to defendants without attorney. Do you recognize this document?
Mhm.
And is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes.
On page 2 of the same document, is this your signature? Yeah, is this your signature on the line that's titled defendant?
Yes, sir.
Ms. Wiley, before you signed and initialed all of these documents, did you read the documents?
Yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Wiley, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, the bailiff need to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over these bond conditions with you. And it states Standard Bond Conditions in County Court at Law Number 2. Following return of accruing information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location of the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. Condition number 5 does apply on the next page, and it states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07, the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition? And condition number 7, we don't have a 6, condition number 7 states the defendant shall wear a global positioning monitoring system device, which is a GPS device, or some people commonly refer to as an ankle monitor, at the defendant's expense, with written verification being submitted to the court within 3 days. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Ms. Wiley, please stand in front of the court coordinator, get your reset. And the locations where you can get the GPS. Once you get your reset, you're free to go and you have a blessed day.
Oh,
Jason Bickford. Mr. Bickford, your full name is Jason Wayne Bickford.
Yes,
Mr. Bickford, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Bickford, you may put your hand down. How you doing, Mr. Bickford?
Okay.
That's good. Mr. Bickford, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line as
Yes.
titled defendant? Or are these your initials on the line that
Yes.
state you'd like to apply for court-appointed attorney? The next document is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes.
Mr. Bickford, before you signed in that initial, all of these documents that I just showed you,
Mhm.
did you read the documents?
Yeah.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Bickford, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you. You'll also be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, I need to give you, the bailiff is going to hand you some bond conditions that I'm going to go over with you. And it states, standard bond conditions in County Court at Law Number 2. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number two, the defendant shall submit to testing for drugs and alcohol at any time, as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number three, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Now, Mr. Bickford, if you violate any one of these conditions, your bond will be revoked.
Yep.
And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail.
Yes, sir.
Now, Mr. Bickford, you can have a seat in that first chair. Wait for your name to be called. Once your name is called, you're free to go. You have a blessed day.
You too.
Javon Jubert. Ms. Jubert, your full name is Javon Rashawn Jubert?
Yes.
Ms. Jubert, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Jubert, you may put your hand down. How you doing, Ms. Jubert? I'm doing fine, thanks for asking. Ms. Jubert, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant's Signature. Is this your signature?
Yes, sir.
Ms. Jubert, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Jubert, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you the information, you're free to go in your blessed day. Please have a seat in the second chair on the wall. Cheyenne Kidling? Yes. You said it on the same, was this, it's the same criminal episode? Okay. Ms. Kidling, your full name is Cheyenne Denise Kidling?
Yeah.
Ms. Kidling, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Kidling, you may put your hand down. How are you doing, Ms. Kidling? That's good. Now, Ms. Kidling, I have before me in your cases a document that is titled Jefferson County, that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yeah.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled that's titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Now, Ms. Kidling, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yeah.
Ms. Kidling, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you is Attorney Don Boudreaux. Attorney Boudreaux will give information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you're free to go and you have a blessed day. Please have a seat in that third chair on the wall.
The same I can say, but her felony was set today. I don't know if she went down there.
I did up here earlier, yes, ma'am.
Oh, she did, yeah.
Yeah.
Did they give you your new court date?
Yes, ma'am.
Okay, she's.
Oh, this July 10th.
Okay, thank you.
Okay. Is that?
Who's that person back there? He's with. Okay, let's get.
Oh, I didn't have, okay,
mean, it's kidney.
okay. Is with Miss Kidley? And who is that? Okay, Miss Kidley, why don't you come on back up? How old are you, Miss Kidley? 21. Okay, so you've been out of high school about 2-3 years? Okay. Now, Miss Kidling, I know you heard the comments I made to that young man. And I'm sure you got some friends too, right? Your BFFs, right?
Yes, sir.
You ride or die, right? But they not here. Are they? No, they not here.
No, sir.
They found something, they got something else better to do, right? I thought they was your ride or die. I thought they had your back. They was gonna be with you through thick and thin. Where are they? You don't even know where they are.
He's all right.
Oh, okay. I bet that man could have been at work too, right? That man took time off to come down here to be with you. You know why? Because that's your ride or die. Okay? That's the one that, as I say, put a roof over your head, clothes on your back, food on your table, a little spanking on your butt every now and then, because he loved you. Okay? So I tell people to say, everybody not your friend, everybody not your partner. But I tell you, that man back there, I know when he say he got you, he got you. Okay. Now, this is not the proudest day in his life. I know he had some good days, he had some bad days like most of us. But this is not one of the good days, the proud days, because he had to take time off from his schedule to be down here with you. But guess what? He's here. Okay. He's here. And that says a lot. That speaks volumes as to the man that he is, what kind of person he is. He's here for you, right? You might think, oh, it's all over for me now. I'm in court, it's all over for me now. My whole future's gone down the drain. It's just been flushed down the drain. It hasn't, right? You might view it as a storm, but like I tell people, when you walking through a storm, just hold your head high. All right? Don't be afraid of the dark. At the end of the sky, at the end of the storm, there's a golden sky and a sweet silver song of the law. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope and hope in your heart. And you'll never walk alone. When you're drowning in confusion and frustration, remember this one thing. Hope floats. Hold on to hope. It's like a light, it's like a one of them life jackets that you put on. It floats. Stop you from drowning in confusion, frustration, depression. Okay? Hold on to your hope. And your hope should be to be the person that man raised you to be. Okay? Not to try to impress your friends. Okay? Because you know what? You're 21 right now. I used to be 21 for 365 days of the year. I was 21. And a lot of them friends that you have at 21, when you get to be my age, you ain't gonna have them. In fact, you might have had them same friends 5 years from now, 10 years from now, right? Because that's how it happens. You're gonna make new friends, okay? And like the old folks used to say, you need to watch the company that you keep, okay? And so I don't want you to think that it's hopeless, that you do not have hope, or that it's all over, because it's not over. This situation is not your final destination. All right? You can use it as a stepping stone, not as a stumbling block, but as a stepping stone to reach higher heights in your life. And you know what? There was another reason why that man is here today, not only because he loved you, because he believed in you. You got to believe in yourself. Sometimes you got to encourage yourself, okay? But you'll be all right. What school you graduated from? Evolution? Oh, good. We had some students from Evolution here last week. Thursday and Friday. Okay. Ms. Durden is the principal over there?
Yeah.
Okay. Okay. But you can change it. Okay. So, are you still in school anywhere? Okay. You working anywhere? Okay. That man is picking up the load. He carrying the load for you. You have to start carrying that load on your own. You still young. All right. You have any kids?
Yeah.
One. Okay. That child, that kid that you have is looking for you to put a roof over their head, clothes on their back, and everything else. Okay. We can give you a brochure to a program at Lamar University. I spoke about it earlier. CICE. Okay. It's a job training program in the hotel industry, the shipping industry, and the chemical industry. They can help you get a job in any area that you train in. Okay. And that'll help you in the long run. Okay. Like my dad used to say, nothing in your head, nothing in your pocket. Okay, so you can get the education and the training that you need so you can help to take care of that child that you brought into this world. Okay. And then before you go to bed tonight, give that man a big hug and thank him for being down here. All right. You have a blessed day. All right. You can get your reset. And thanks for coming down here with her. Okay. Okay, now this Baker,
Amber Brown, she said no, she's in the hospital.
what, Brown? Okay, so that's, we gotta, okay, be in the hospital. Who did it's William Wilkerson. Okay,
Brown.
yes, on bottom of page 3. Where are we on, somebody named Delvin Baker? There's a bondsman? Oh, I see that. Is that out of county? Never heard of it. Is that in county or out of county?
Out of town.
Okay, I don't, okay. Yeah, they didn't, we show that I see here that the bondsman received notice.
Well, we can
April-
first look at that on the first one, notice was returned on 5/22, gave court date to person with Alexa bail.
Oh, you did?
Yes, sir.
Okay. Wow,
This one is something like they didn't have a mailbox.
right, but you told them when the court date was,
Curse.
okay. Court is back in session and clause numbers 23 CCCR 1488, clause number 23 CCCR 1489, clause number 24 CCCR 0307, clause number 24 CCCR 0308, clause number 24 CCCR 0309, and clause number 24 CCCR 0310. All 6 cases are styled the state of Texas versus Delvin LaRon Baker. Delvin Baker was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., Delvin Baker's name was called at the courthouse door. Delvin Baker did not answer. Delvin Baker has not appeared in court since the court has been in session. The time now is 11:07 a.m. on today's date of May 27th of 2025. Ms. Bailiff, would you please call the name of Delvin Baker at the courthouse door?
Delvin Baker. Delvin Baker. Howard Bonjour.
Delvin Baker's name was just called again at the courthouse door by the court's bailiff. Delvin Baker did not answer. Delvin Baker has not appeared in court since the court has been in session. State, do you have a motion?
Statements for bond forfeiture in all cases.
Those motions will be granted. Delvin Baker's bond will be forfeited and his warrant and warrant will be issued for his arrest in each case. Cause numbers 23 CCCR 1488, cause number 23 CCCR 1489, cause number 24 CCCR 0307, cause number 24 CCCR 0308, cause number 24 CCCR 0309, and cause number 24 CCCR 0310. Next case is cause number 24 CCCR 0704. Case is styled the state of Texas versus Martavian Francois. Martavian Francois was scheduled to be in court this morning at 9 a.m. at about 9 a.m. Of course, bailiff called the name of Martavian Francois at the courthouse door. Martavian Francois did not answer. Martavian Francois has not appeared in court since the court has been in session. The time now is 11:09 a.m. on today's date of May 27, 2025. Ms. Bailiff, would you please call the name of Martavian Francois at the courthouse door?
Fabian Francois. Fabian Francois. George Bonjour.
Martavian Francois' name was just called again at the courthouse door. Martavian Francois did not answer. A reasonable time has passed to give Martavian Francois an opportunity to report. He is not appearing in court. State, do you have a motion?
Statements for bond forfeiture.
That motion will be granted. Martavian Francois bond will be forfeited and warrant should be issued for his arrest. And cause number 24 CCCR 0704. Next case is cause number 25 CCCR 0636. Case is styled the state of Texas versus Kareem Abdul Johnson. Kareem Johnson was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, bailiff called the name of Kareem Johnson at the courthouse door. Kareem Johnson did not answer. Kareem Johnson has not appeared since the court has been in session. The time now is 11:10 a.m. on today's date. Ms. Bailiff, would you please call the name of Kareem Johnson at the courthouse door? Okay, Kareem Johnson's name was just called again at the courthouse door. Kareem Johnson did not answer. A reasonable time has passed to give Mr. Johnson an opportunity to appear in court. Is not appearing in court. State, you have a motion?
Statements for bond forfeiture.
That motion will be granted to Kareem Johnson. Bond will be forfeited and warrant should be issued for his arrest and cause number 25 CCCR 0636. Next case is, well, next two cases are cause numbers 25 CCCR 0001, cause number 25 CCCR 0002. Both cases are styled the state of Texas versus Jeffrey Scott Pope. Jeffrey Pope was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, bailiff called the name of Jeffrey Pope at the courthouse door. Jeffrey Pope did not answer. The time now is 11:12 a.m. on today's date of May 27 of 2025. Ms. Bailiff, would you please call the name of Jeffrey Pope at the courthouse door?
Jeffrey Pope. Jeffrey Pope. No response, Your Honor.
Jeffrey Pope's name was just called again at the courthouse door. Jeffrey Pope did not answer. Jeffrey Pope has not appeared in court since the court has been in session. State, do you have a motion?
Statements for bond forfeiture.
Those motions will be granted in each case. Jeffrey Pope's bond will be forfeited and warrant should be issued for his arrest. In cause numbers 25 CCCR 0001 and cause number 25 CCCR 0002. And this will conclude the calling of the court's arraignment document and the court's trial docket on the day's date of May 27, 2025. Court will be in recess until 1:30. We'll pick the jury for the trial that we have this afternoon. Yeah. Yes.
His notice was returned.
Oh,
Resend it back.
oh,
State will recall that bond forfeiture.
okay. Okay, so Jeffrey Pope, that'll be recalled. And we're gonna reset him for when?
So this is.
He's an out of county bondsman or what?
I
Oh,
want some.
okay. Okay. So we'll reset it. Would it be in recess to 1:30 this afternoon? You want-